For a security interest to be enforceable under Article 9 of the Uniform Commercial Code, the parties must execute a security agreement. But what if the security agreement contains an error? Can a creditor use evidence outside of the security agreement, known as parol evidence, to prove the validity of its security interest? The Seventh Circuit considered these questions in the case of N. Ray Duckworth. David Duckworth borrowed $1.1 million from the State Bank of Toulon. The transaction was memorialized with two documents, a promissory note signed and dated December 15th and a security agreement dated December 13th. The security agreement granted the bank a security interest in Duckworth's crops and farm equipment in exchange for the promissory note. However, the security agreement referenced a promissory note dated December 13th. No such note existed. The only promissory note in the transaction was the one dated December 15th. A few years later, Duckworth filed for bankruptcy. The bank filed an adversary proceeding in bankruptcy court to enforce the security agreement. Seeking to maximize recovery for unsecured creditors, the bankruptcy trustee objected, arguing that the incorrect date made the security agreement ineffective and thus defeated the bank's asserted security interest. The bankruptcy court disagreed and ruled that the bank could enforce the security agreement. The district court affirmed. The bankruptcy trustee appealed to the Seventh Circuit.